Roger McEowen with Washburn University School of Law joins us now for an update on that matter. Roger, as always, thanks for your time. If you could give us just a brief background on the state laws and the objective.
Well, good to be with you, Janet. The basic idea of state legislatures that have attempted to provide a level of protection to livestock facilities is to bar access to an animal production facility under false pretenses. So you can't lie to get access is the basic idea. So at their core, the laws attempt to prohibit a person that has the intent to harm a livestock production facility from gaining access to the facility, either by employment or other means, to then commit illegal acts once they're on the premises.
So what are some of the challenges that have come up from these laws so far?
Well, as you indicated in the open, the laws have generally been struck down on free speech and equal protection grounds. So they've run up against that problem in the federal district courts and courts of appeals across the United States.
Can you bring us up to speed on this latest case?
Well, the Iowa legislature has made two attempts over the past decade at crafting a state law that would withstand a constitutional challenge. The initial version criminalized agricultural production facility fraud if a person willfully obtained access to such a facility by false pretenses. So that's the access provision, or made a false statement or representation as part of an application or agreement to be employed at the facility. That's the employment provision. The law also required these persons to know that the statement they made was false at the time it was made, and that it was made with the intent to commit a knowingly unauthorized act. So it has all of those elements. The initial statutory version was challenged, and the employment provision was deemed unconstitutional. So the legislature came back and retooled the statute. But just last week, the court said it's not much different than the first version. And so the new version met the same fate in the federal district court.
So, Roger, what is the big takeaway from this situation? And do you think that we could expect future court cases?
Well, with the appellate courts generally holding that the right to free speech protects false factual statements that inflict real harm and serve no legitimate purpose, that actually runs contrary to an established line of U.S. Supreme Court precedent, at least until the court's 2012 decision on the Stolen Valor Act. But there was a strong dissent in that case. But there's also currently a split between the 8th, 9th, and 10th circuits on the Iowa, the Idaho, and the Kansas law on the constitutionality of those state laws with respect to the issue of gaining access to a covered facility by lying. That could warrant a Supreme Court review. So maybe the Supreme Court will be asked to clarify things.
All right. Well, Roger, as always, thanks for your insight on the matter. Roger McEowen, he's with the Washburn University School of Law. You can go online to washburnlaw.edu/WALTR for more information. Thanks, Roger.